Hello everyone, it is lawbyreece here, back with another video, and in this video we've got 3 orders all denying the defendant's motion for mistrial, which is an outcome that I had expected, guys. Alright guys, it is Reese here. I'm an attorney licensed here in the state of Texas, specializing in criminal defense and debt collections. I want to thank you guys for joining me. If you like this content, please make sure to use the donation links in the description box below. There's a number of options: CashApp, Venmo, Bitcoin, Ethereum, and Doge, as well as Buymeacoffee, guys, which is a Stripe provided service. Want to give a big thanks to Charles H. Charles H. recently donated $25 to the channel through Buymeacoffee. Want to give a big thanks to him for that, guys. Okay, with that housekeeping out of the way, guys, let's get into these orders. As you know, the primary format that I like to analyze cases is I like to go through the written motions. There are a number of YouTube channels which go into the courtroom drama itself, that video record the courtroom drama. Law and Crime, Cat Not Williams, The Lead Attorney. These are all folks that are live streaming the court proceedings, the YSL trial. I, on the other hand, just like to stick to reading and analyzing the written motions, written orders, written material. Guys, it gives me something to work with, and that's just really what I prefer to do. So from that angle, let's continue, guys. So in my prior videos, I had read and analyzed the motion to disqualify prosecutors Love and Hilton, and I did explain that I thought it would be denied, although I thought it was a good motion, but I did think it would be denied, and it was in fact denied. Okay, guys, here we have the order denying Defendant Williams' amended additional motion to disqualify lawyers Love and Hilton in the Superior Court of Fulton County, State of Georgia. State of Georgia v. Jeffrey Williams, indictment number 22 SC 183-572, Judge Whitaker. Defendant Williams asserts that prosecuting attorneys Love and Hilton must be disqualified from the case because of alleged ethical violations during the course of the trial in this case. As noted in the court's August 1st, 2024 order, a defendant seeking disqualification of prosecutors in a trial bears a, quote, heavy burden of proving that such an extreme action is warranted. See, for example, Lewis v. State, 312 Georgia Appellate 275, 283, 2011. And then this is a quote from that opinion. Quote, "It is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted." So, guys, I've pulled up here Lewis v. State and gone down to page 312. And here we go, guys. Let's see, excuse me, page 283, right? So here we have page 283 of the Georgia Reporter. And let's start. Because of the right involved and the hardships brought about by its deprivation, disqualification of chosen counsel should be seen as an extraordinary remedy and should be granted sparingly, quoting Bernocchi, 279 Georgia at 462. And it is the burden of the party seeking to disqualify counsel to prove that the extraordinary remedy of disqualification is warranted. See Hastings, 197 Georgia App 508 at 509. With these principles in mind, we now turn to the disqualification of Brown and his firm in this case. So I won't get through all of that language, guys, but needless to say, what I'm pointing out here is you can see that the judge is citing to Lewis v. State, 312 Georgia Appellate, starting at 275 in that reporter, and that quote is at 283. And that is the proposition of law that the judge is using to basically state that the defendants have not met their, quote, heavy burden of proving that such an extreme action is warranted. Now, you might wonder to yourself, if withholding Brady information and repeatedly lying or lying by omission, or I want to say withholding some exculpatory evidence for over a year, I mean, other than, the prosecutors going out and shooting the defendants, I don't know what sort of extreme action, what does extreme action look like? But guys, this is where there's some wiggle room in the law. What is an extreme action? I don't know. But personally, do I think that these defendants have met that heavy burden of showing, yeah, I mean, it looks like the prosecutors were purposely withholding Brady or exculpatory evidence, which to me meets that heavy burden for such an extreme action. They also had multiple ex parte meetings with Judge Glanville, which I think at least had the auspice, the auspice of looking improper. So do I think personally, although I'm not the judge, do I think that these defendants met their heavy burden of such an of proving such an extreme action is warranted? Yeah, I do think so. Okay, guys, and then also I just wanted to show you how you read this. This citation signal is C, for example. And then C, going to the blue book, cited authority clearly supports the proposition. C is used instead of no signal when the proposition is not directly stated by the cited authority, but obviously follows from it. There is an inferential step between the authority cited and the proposition it supports. And then we have, for example, cited authority states the proposition. Other authorities also state the proposition, but the citation to them would not be helpful or is not necessary. So what are some other authorities here? You can see Bernocchi and then Hastings v. Cortland, so that's why the for example is in there. When it is attached to another signal, it should be preceded by an italicized comma and followed by a non-italicized comma. So there's some just quick analysis for you. Defendant has submitted 8 examples, and then we see here 8 written out, followed by numeral 8, of alleged misconduct and or ethical violations which have occurred in the approximately 8 months that the trial, since opening statements, has been ongoing. Certain of these items are also enumerated in Defendant Stilwell's renewed motion for a fair and constitutional trial. To the extent they are addressed and ruled upon there, such rulings control. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulously honored, and prosecutors above all should endeavor to comport themselves so as to be above reproach on such matters. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occur during and impact on a case before this court. The court declines that invitation at present. The court certainly does not condone the alleged actions of prosecutors Love and Hilton. The court has, in the weeks since assuming presiding duties, made clear the expectations of all counsel, and the court admonishes counsel that any future failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction of removal from this case. Upon consideration of defendant's motion and the applicable law, defendant's additional amended motion to disqualify prosecutors Love and Hilton in this trial is denied. So ordered this 8th day of August, 2024. So, just to give you some brief thoughts on this, I did not expect that the judge would grant the first motion to disqualify the prosecutors in this case. I was not expecting that to be granted, but we do see some admonishing language here. So, you know, if I were prosecutors Love and Hilton at this point, I'd be very careful not being fully candid with the court. But not as surprising to me that they get quote unquote one free pass. Okay, now we have the order on Stilwell, renewed motion for for fair and constitutional trial. Okay, guys, defendant Stilwell raises numerous assertions of, quote, error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts have resulted in a denial of his constitutional rights to due process and a fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Now, here we have Claim 1, a plague of discovery violations, missing police reports, and Brady violations, paragraph number 6. So guys, if you are not familiar with this symbol, that means paragraph. Paragraph 6. Discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current Atlanta Police Department personnel with specificity to search for and produce reports on the case. As recently as the court proceedings of Friday, August 1st, 2024, the court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items, and reminded the state of its continuing obligations under Brady. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Claim number 2, prosecutorial failure to follow court orders, making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court, cited at paragraphs 7, 10, 22, and 23 of Shannon Stillwell's motion. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial's defendant's rights to due process and a fair trial, no specifics establishing this assertion and no claim of resulting legal error is alleged. Any potential error stemming from prosecutorial failure to follow court orders may be addressed on motion for new trial and/or direct appeal, assuming any conviction. Any specious allegations against defense counsel, counsel for a witness, or lack of candor within the court is, at a minimum, extremely unfortunate. And then here we have footnote number 1. This is the footnote from the prior order, so I'm not going to read that one out loud. These items do not, however, establish a denial of defendant's rights to due process or a fair trial. And then we have footnote number 2. Footnote number 2 reads, the state's June 7, 2024 motion for immunity and compelled testimony of Copeland states, quote, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland might attempt to plead the Fifth in order to avoid testifying against members of YSL. Motion at paragraph Roman 11. Even assuming that this is a willful misrepresentation, as opposed to inartful drafting or misunderstanding, the gravamen of the representation is that Copeland had indicated he might plead the Fifth to avoid testifying in this trial. The sequence of alleged events is not the material aspect of the motion. Okay, these items these items do not, however, establish a denial of defendant's rights to due process or a fair trial, and the court at present declines to impose the extreme sanction of removal of any offending prosecutors. Claim 3, improper evidentiary rulings by the predecessor judge, paragraphs 8 and 9c. Quote, a defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. People v. State, 295 Georgia, meaning the Supreme Court of Georgia, 44 at 45, 2014 case. And then here we have citations omitted. So, let me, 646, I want to find people, see that. Peoples v. State, and then I want to find at 55. Yeah, so here we go. Paragraph sub C here. Not all trial errors require reversal, however. Quote, a defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. And then we see a citation to Sutton v. State. So, again, we have a lot of citations cleaned up. So, again, that is, you can't, I want to give you my brief thoughts on that. The issue here, and you can see the judge in her reasoning, is that there's a lot of wiggle room in the opinions to which the judge is citing. And the judge is citing here a Georgia Supreme Court opinion. And the judge is characterizing this current trial as not perfect, but still constitutionally fair. Were I the presiding judge, I'm not, but were I the presiding judge on this case, I would say that the violations thus far have rendered this trial constitutionally unfair. But you can see the line between constitutionally unfair and no perfect trial, and the judge has decided to go on no perfect trial and to push on with the trial. And so, guys, this is where there is discretion in the law. So the law is not black and white. The law is discretionary, and you can see it. You can see it here. What's the line between a fair trial, a constitutionally unfair trial, or a perfect trial and not a perfect trial? So what's that line there? And that's up to the judge. Quote, evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, can be addressed in post-trial review. Claim number 4, mistreatment of defendants and their counsel by the predecessor judge, paragraph 9, A, B, D, E, and H. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. The alleged mistreatment of defense counsel, detailed in paragraphs 9, A and E, and H, is not alleged to have occurred in front of the jury and, even accepted at face value, would not rise to the level of a violation of defendant's due process or fair trial rights. As to remedies, the predecessor judge has been recused, and the contempt issued outline in paragraph 9H is moot. So mootness meaning that issue is no longer ripe for adjudication. Turning to alleged mistreatment in front of the jury, paragraph 9B and D, a judge has broad latitude in determining how to control the courtroom and directing attorneys to, quote, sit down when overruling objections falls within that latitude. This court will give a remedial instruction directing the jury to disregard any disparaging remarks about counsel. Claim number 5, improprieties and illegality of the June 7, 2024 ex parte conference, paragraphs 20 through 27. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court. June 7, 2024, transcript, page 94. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Copeland, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this June 7, 2024 conference, no one on the defense team objected to the request or sought more information about it, thereby waiving any right to be present for that conference. See, for example, and then we have a citation in Nesby v. State, and we have a parenthetical here. For the proposition that, quote, defendant waived right to be present by failing to object after being informed of the trial judge's meetings with the jury outside the presence of defendant and counsel. As for topic of this ex parte conference, defendant assigns nefarious intent to prosecutor Love's and Hilton's representations about their interactions with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to so view their representations, but refers the prosecutors to its footnote 1 herein. Defendant complains that comments by the predecessor judge during this conference reveal his partiality to the state. Pre-termitting the questionable accurateness of such characterizations, the issue has been mooted by the recusal of that judge from the case. Claim 6, illegality of the June 10th, 2024 ex parte meeting. On June 10th, 2024, at the behest of Prosecutor Love, the predecessor judge held an on-the-record in-chambers meeting with Love and stand-in counsel for Copeland, Kayla Bumpus. June 7, 2024, transcript of ex parte, page 3 through 22. Following a recess, at which time Love departed the meeting, Copeland and Prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? Number 1, did defendant have a right to be present? Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with the logistics of handling Copeland's testimony with stand-in counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core, and as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant had a right to be present. See Snyder v. Commonwealth of Massachusetts. This is a Supreme Court case from 1934. Criminal defendant has a right to be present when his presence, quote, has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when, quote, his presence would be useless or its benefit but a shadow. United States v. Gagnon, 470 U.S. 522 at 526, 1985 case. Quote, the presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. Defendant is correct that there are differences between the meeting in this case and the meeting in King v. State. And here we have 539 Southeast 2nd, 783, 2000 case, cited by the state. For instance, the meeting in King was to secure immunity for a key prosecution witness, and the defense was aware that the immunity hearing was occurring. Here, the defense was not given notice of the meeting, and immunity had already been granted to a key prosecution witness, so the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of the witness's legal representation and logistics about stand-in representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant, what would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. And that's all speaking about Kenneth Copeland. But the state's reliance on King does not demand that its facts be on all fours. The legal import of King for this claim is that because a defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant, a defendant has no right to be present for discussions with the tribunal surrounding witness immunity. The fact that here discussions included what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. And then here we have a citation to a Kansas case. No right to be present at hearing to compel witness testimony pursuant to immunity grant. And then we have a New York case. Ex parte meeting at trial court's behest between court, prosecutor, and counsel for witness initiated after defendant and his attorney had left the courtroom during a recess at the close of the witness's direct examination, and held to ensure the witness understood his deal with the prosecution and that he was not unknowingly incriminating himself, and understood his constitutional rights, held to be a, quote, ancillary proceeding dealing only with the rights of the witness, at which defendant had no right to be present. And then I want to give you guys a definition of ancillary. Ancillary meaning subordinate or subsidiary, or meaning auxiliary or supplementary. The need for ancillary evidence. The word derives from the Latin word ancilla, meaning a female servant, which also gave us the rarer English word ancilla, meaning an aid to achieving or mastering something difficult. Ancillary picks up on the notion of providing aid or support in a way that supplements something else. In particular, the word often describes something that is in a position of secondary importance, such as the ancillary products in a company's line. Was the witness's testimony coerced? Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations, and the length of his possible incarceration for contempt coerced Copeland into testifying. Then we have Webb v. Texas, 409 U.S. 95 through 96. So this is a U.S. Supreme Court case. Webb v. Texas is the touchstone for evaluating claims of coercion by the trial court of a witness's testimony. And then we also have Archer v. State, 383 Maryland, 329, 335 through 351. And that's 859 Atlantic 2nd at 210. That's a 2004 case. Provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness's determination whether to testify. So I remember back in criminal law class, I think I remember reading Webb v. Texas. Here, Copeland had the benefit of counsel. The predecessor judge did not on the whole use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not induced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to pre-termit this issue, acknowledging past inaccuracies, and advise Copeland anew. This is the course that the court has proposed, and the parties affirmed its efficacy. And then, guys, I'm going to give you a definition quickly of efficacy. Efficacy, the power to produce an effect. And then here we have recent examples. Successful trial results have pointed to the rival firm's drug efficacy, or the power to produce an effect. All right, was there a Brady violation? This has been a long-running and multifaceted proceeding. Challenges have been myriad and formidable. Let me give you all a quick definition of myriad. Myriad, 10,000 or a great number. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning. And now we have the judge writing poetically. And a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue. And yet, as soon as Copeland joins the June 10, 2024 in-chambers ex parte proceeding, he states, quote, "I have never been truthful a day in my life until I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole. But the fact remains that for a defense attorney, this nugget by a key state's witness is gold. I really like the judge getting in here into poetry. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. So what does Brady, that case, Brady v. Maryland, 1969 case, what does it stand for? The prosecution in a criminal case under the law must turn over to the defense all exculpatory or tending to show innocence evidence. What is impeachment? Impeachment is not necessarily a statement or a piece of evidence that you're going to bring in as substantively trying to prove up or disprove a legal point or an element of a charge. Impeachment material is simply what you use to show that someone is lying or has inconsistent testimony. In other words, you're trying to discredit that witness using that material. So basically the idea is this quote here, "I have never been truthful a day in my life until I made this statement right now." Basically, Copeland is a known liar and admits to being a liar. And so if you're on the defense and Copeland is the witness that the state is using to convict your clients, You're going to hand up to the jury and you're going to go, here, you can't trust anything that this guy says. I have never been truthful a day in my life until I just made this statement right now. And the judge is right. That's literally gold, and you need that. That's Brady impeachment material, 100%. Not even a gray area on that. The defense now knows of this statement, and indeed of all of what occurred during the June 10th, 2024 ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce/suppression of this information does not technically amount to a Brady violation. But the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration. What it does provide is cause for sober reflection and an examination of processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse. Notice she doesn't say Brady violation, but Brady lapse to occur. The defendant seeks as a sanction the disqualification of the state's 2 lead prosecutors. Because this does not appear to the court to have been a purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statement, the court does not order their disqualification. At the same time, the court is cognizant that, all right, I'm going to give you all a quick definition of cognizant. Cognizant, knowledgeable of something, especially through personal experience. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake, that the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously presented by the Prosecuting Attorneys Council of Georgia. The court will provide the video, and the viewing will occur under the direction of the court. So, kind of like when you get hit with a DWI, one of your pretrial diversion clauses might be that you have to take a course on driving while intoxicated. Well, the judge, and I think this is pretty funny, but the judge is ordering prosecutors, the entire prosecution team, to attend training on Brady evidence, which is hilarious. All right, and we have the final motion here, guys, which is, or the final order denying defendant Kendrick's motion for mistrial and supplement to same. This is State of Georgia v. DeMonte Kendrick. Before the court is defendant Kendrick's July 23, 2024 motion for mistrial, supplemented on July 31, 2024. The court has also considered the state's response, oral arguments by the parties, the transcripts of the June 7th and June 2024 ex parte proceedings, and the applicable law. The motion for mistrial asserts 3 grounds for mistrial, with the supplement asserting a related 4th ground. 1, that it is impossible to redo the proceedings that occurred on June 12, 13, 14, and 17 before the jury in the interim between defendant's June 12, 2024 motion to recuse the predecessor trial judge and his ultimate recusal. Okay, guys, I'm going to briefly scan through this order. They're all orders denying mistrial, but I need to get going, so I'm going to just briefly scan through this. So here we have a statement on impossibility of addressing or redoing the proceedings. As such, the court does not find that there is an impossibility to addressing these issues, and therefore there is not a basis to grant defendant Kendrick's motion for mistrial. So basically the judge is saying that, yes, we can redo the issues. All right, the June 10th, 2024 ex parte meeting. And then basically we see the same here, same argument here, that it doesn't rise to due process violations. And then we have the ex parte meeting was at a critical stage and violated Kendrick's rights. So here we have, because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant had the right to be present. Here we have that same quote from a U.S. Supreme Court case. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. And then we have the same argument here on the predecessor judge improperly coerced Copeland to testify. And then bias on the part of the predecessor judge. Based on the comments in the ex parte transcript made by the predecessor judge about counsel, both for the defendants and witness Copeland, as well as about, quote, outside agitators, defendant asserts that the predecessor judge during this conference revealed his partiality to the state. Pretermitting the questionable accurateness of such characterizations and or discussions, this issue has been mooted by the recusal of that judge from the case. Wherefore, for all of the foregoing reasons, defendant Kendrick's motion for mistrial and supplement to same are hereby denied. So the idea on that is the Judge Whitaker here is not even commenting on whether Judge Glanville was biased or not, because that issue has been rendered moot by his recusal. And I will be honest, I know this is not a very popular opinion on the internet, but if you understand the idea of mootness, meaning that is not an issue that can be adjudicated, I have to agree with the judge here that the recusal renders that argument moot. And then I can see the judge's reasoning here. So I did not think that a mistrial would be granted, and it wasn't granted. I think it's hilarious that the prosecution team has to attend a training video on Brady material. I think that's hilarious. But overall, guys, I don't see anything that terribly surprises me. I think personally that this should have been declared a mistrial, but that's my opinion. But I don't think it's really based on the impartiality of the prior judge. I agree with this judge. What I think that it should have been a mistrial for is the withholding of Brady material. I think that's the number one most concrete example of prosecutorial misconduct is the withholding and suppression of Brady material. I do not agree with this judge that with the suppression of this Brady material, especially that statement by Copeland that he always lies and he's a complete liar. I am not convinced that the judge's assertion that it appears to be inadvertent negligence, I don't agree with that, and I think that's way too generous. That's way too charitable to these two prosecutors. I think given the fact that especially Love and Hilton have been shown just to be deceitful, I think. I don't think that I think the evidence is clear that especially that statement, I think it was intentionally withheld. And I think that suppression and withholding of Brady material was the number one most concrete manner by which this case should have been rendered a mistrial. But I agree with the judge that the recusal of the prior judge would render a statement on Judge Glanville's partiality probably moot. I agree with that, but with that being said, I think that this should have been declared a mistrial, but not surprised that it wasn't. Okay, guys, this has been Law by Reese here, back with another video. Today, we covered the 3 orders denying motions for mistrial, but we also saw that the prosecution team is now going to have to attend training on Brady material, which I think is pretty funny. Okay, bye-bye.